Morning, everyone.
Morning, Vivian.
Morning.
All right, I'm going to call the meeting to order. We've got a lot of business ahead. It is 9:00 a.m. exactly, and I'm calling to order the regular meeting of the Board of Retirement. Bonnie, I believe you have some housekeeping announcements for us.
Yes, thank you, Chair Bernstein. This meeting is being conducted as a virtual meeting, so I will go ahead and do a roll call of the trustees at this time. Mr. Pryor,
Here.
Mr. Knox,
Good morning, I'm here.
good morning, Ms. Gray,
Present.
Mr. Santos,
Present.
Mr. Oakham,
I'm here.
Mr. Moore,
Here.
Mr. Kehoe,
Present.
Mr. Robbins,
Present.
Mr. Harris,
Present.
Ms. Zapanta,
Present.
Chair Bernstein.
Here.
Staff participating in the meeting include the CEO, Santos Kryman, AEO, JJ Popowich, Interim Chief Counsel, Johanna Fontenot, Senior Staff Counsel, Frank Boyd, Legislative Affairs Officer, Barry Liu, Chief Investment Officer, John Grable, LACERA's Medical Advisor, Dr. Vito Campisi, Interim Systems Manager, Kathy Delino, CISO, Bob Slofelt, Chief Audit Executive, Richard Bendel, and Principal Internal Auditor, Christina Logan, and Division Managers, Cassandra Smith and Ted Granger, Disability Retirement Specialist Supervisors, Tamara Caldwell, Vicki Neely, Carrie Wilson, Ricardo Salinas, and Hernan Barrientos, Vincent Lim, Jason Waller, Allison Barrett, and Eugenia Durr from the Disability Litigation Team, and consultants Ashley Dunning and Peter Mixon from Nossaman. Trustees, if you have a comment or question on any item, please use the Zoom chat option to be placed in the queue. And at this time, we ask all the meeting participants to mute their mics until you are ready to speak. Chair Bernstein, we may now proceed with the agenda.
Thank you very much, Bonnie. We're on to item 2, approval of the minutes. Unless there is some controversy of which I'm unaware, I'd be happy to entertain a motion to approve both minutes.
So moved.
Second.
It's been moved and seconded. Bonnie, can we take a roll call?
Mr. Knox,
Aye.
Ms. Gray. I'll come back to you, Ms. Gray. Thank you. Thank you. Mr. Santos,
Aye.
Mr. Oakham,
Aye.
Mr. Moore, Mr. Moore.
Aye.
Thank you. Mr. Kehoe. Okay, I see you. Thank you. Mr. Robbins.
Aye.
And Ms. Zapanta.
Aye.
Thank you. And Chair Bernstein.
Aye.
The motion passes unanimously.
Thank you, Bonnie. Item 3, public comment. I am not aware of any slips from the public. So we are on to item 4, other communications, and we'll start with March 21 All-Stars. JJ, take it away.
Thank you very much, Chair Bernstein, and good morning to all the trustees. This is the time of month when we recognize those staff members who go above and beyond Call of Duty and exhibit all of our values and what we stand for and service our members. And so if they're out there, please virtually stand. You can see their pictures on the screen. Sarah Robles, Steve Salinas, Courtney Cook, Scott Rhodes. Our rideshare winner is Priscilla Hernandez, and web watcher was Percy Petrov. So thank you very much for everything that you guys do. You are greatly appreciated.
That's great. And thank you for including the pictures. We are now on to our CEO report. There is a memo dated April 26th. Santos, take it away.
Yes, Chair Bernstein, trustees, good morning. I just wanted to brief you on one additional item that was included. It is included in my report, but I wanted to give you an update on our recruitment for the Chief Operating Officer. So we have completed all of the interviews with the finalists. We're in the process of making an offer to one specific individual. Before we finalize that, they'll have to go through a background check and several other steps before we can announce the individual and schedule a time for them to join the LACERA team. And so I'm hopeful that the individual will be here sometime in June or in July at the latest, depending on the arrangements that they'll have to make with their current employer. So I just wanted to make sure that you're aware that we're moving forward with that particular recruitment. Also, the AEO position for administration has also been, that announcement is out. And so we're accepting applications for that position. And so we're moving forward with trying to fill all of the leadership positions that we need in order to move LACERA forward. So with that, my report is in the record, and I know that we have a very full agenda, so I'm more than happy to stand for questions.
I don't have anyone in the queue. Are there any questions?
And I just have one question. And looking at the list, there are no IT jobs on here. Is there a reason for that, Santos?
We didn't list those jobs. That'll be a discussion that we're going to have at the OOC later this afternoon, hopefully this morning.
Okay,
And so we'll discuss the plan that we have moving forward. But those items are ready to go once we describe the hiring plan on the IT side with the OOC. Okay.
any progress with our friends downtown?
We have not, we're in the process of actually updating all of the compensation studies that we had completed back in 2018. So we want to update and refresh all of the information before we actually go back to the CEO's office and discuss our next steps in terms of processing those items that have already been approved by the Board of Retirement and the Board of Investments.
And we really only have in dispute 5 positions. Is that correct?
For some reason, the number 6 sticks in my mind. I think there's
6? Okay.
Yes, 5 or 6.
That,
So we're working through all of those at this particular point in time. So
okay, thank you.
updating the information is important.
Great. I want to thank you and staff for getting through another March Madness. I know that's always an exciting time of year, so congratulations on that. And if there are no other questions, and I see none, we will move on to item 5, which is disability retirement applications on consent calendar. I'm not aware of any requests to pull cases, so we will go through these in order. First are SED applications for safety, applications number 451D through 468D. I'll take a motion.
So moved.
So moved. Second.
Been moved and seconded. I think we need a roll call.
Mr. Knox,
Aye.
Ms. Gray,
Yes.
Mr. Santos,
Aye.
Mr. Oakham,
Aye.
Mr. Moore,
Aye.
Mr. Kehoe, Mr. Robbins,
Aye.
Ms. Zapanta,
Yes.
Chair Bernstein.
Aye.
The motion passes unanimously.
Thank you. And those were law enforcement, sheriffs, and DA investigators. Now we have safety SCD applications for fire and lifeguards, application numbers 1349B through 1352B.
So moved.
Second.
Moved by Pryor, second by Oakham. Roll call, please.
Mr. Pryor,
Aye.
Mr. Knox,
Aye.
Ms. Gray,
Yes.
Mr. Santos,
Aye.
Mr. Oakham,
Aye.
Mr. Moore,
Aye.
Mr. Robbins,
Aye.
Ms. Zapanta,
Yes.
Chair Bernstein.
Aye.
The motion passes unanimously.
Thank you very much. We are now on to SCDs for general members, application numbers 2213C through 2228C.
Move approval.
Second.
Moved by Santos, seconded by Oakham. Roll call, please.
Mr. Knox,
Aye.
Ms. Gray. I'll come back to you, Ms. Gray.
Yes.
Thank you very much. Mr. Santos,
Yes.
Mr. Oakham,
Aye.
Mr. Moore,
Aye.
Mr. Kehoe,
Aye.
Mr. Robbins,
Aye.
Ms. Zapanta,
Yes.
Chair Bernstein.
Aye.
The motion passes unanimously.
And finally, we have a general member NSCD consent application for application 4403.
Move approval.
Second.
Moved by
Okay.
Santos, seconded by Gray. Roll call, please.
Mr. Knox,
Aye.
Ms. Gray,
Yes.
Mr. Santos,
Yes.
Mr. Oakham,
Aye.
Mr. Moore,
Aye.
Mr. Kehoe,
Aye.
Mr. Robbins,
Aye.
Ms. Zapanta,
Yes.
Chair Bernstein.
Aye.
The motion passes unanimously.
Thank you. Thank you, Bonnie, for all those roll calls. We are on to item 6, consent items. There's a question on item B, so I'm going to pull item B. Let's, if I can, get a motion for consent items A, C, D, E, and F, and then we will immediately let Mr. Moore ask his question and consider item B separately.
So moved.
Moved by Oakham. Was it Kehoe? Is that a second? Roll call, please.
Second.
Mr. Knox,
Aye.
Ms. Gray,
Yes.
Mr. Santos,
Yes.
Mr. Oakham,
Aye.
Mr. Moore,
Aye.
Mr. Kehoe,
Aye.
Mr. Robbins,
Aye.
Ms. Zapanta,
Yes.
Chair Bernstein.
Aye.
The motion passes unanimously.
Now we'll take up item 6B. This was a recommendation submitted by Mr. Kelly, the chair of the audit committee, that the board approve and adopt the revised audit committee charter. There's a memo dated April 27th, and there is at least one question.
Yes, I don't have any objection to item B. I just have a question about the procurement process for acquiring whatever additional audit or professional services are required by the committee. And I want to know if that process is run by the CEO or the staff, and that we're going to be assured that there's going to be the proper outreach, due diligence, negotiations, etc.
Mr. Bendel, do you want to answer that?
Yeah, good morning, Chair Bernstein and the trustees. Good morning, Mr. Moore. Yes, the procurement process will be run by staff, and actually we took a pool of audit firms to the committee for approval, so that selection of the pool was made by the audit committee, and all actual assignments or jobs that are hired for those firms, any audits that are hired, that we hire the firms for, we'll be bringing them back to the committee for selection after we bid the assignments out. So and outside of that pool, we'd also be bringing them back to the committee. So it will be a controlled procurement process that will go directly back to the audit committee for approval on all, and will be handled in accordance with the procurement policy as well, fairly and equally.
Okay, what's the policy on sole source procurements?
Yeah, I'm not the expert on that, but I think you can sole source in instances where you there's a justification for it, where there's only one provider, or you have other justification that rationale that, but you have to provide a justification letter, and obviously that needs to be vetted and approved, and that would then also have to go back to the committee for approval.
Okay, does the CEO get involved in the sole source process?
I don't believe so. Not in relation to the audit process. I think the audit committee, for the purpose of independence, wanted to keep the process directly between staff within internal audit and the audit committee. Unlike the general procurement process, where staff would go up through the CEO, and then I think the CEO has discretion up to $150,000, and then to the boards for approval beyond that. In the case of the audit selection of and hiring of auditors, staff takes that to the audit committee for approval.
Yeah, okay, well, I just have this question in my mind about the audit committee being able to direct procurements under a threshold amount with no oversight except after the fact. Not that, they would do that. It's just that from a process standpoint and oversight, checks and balances, however you want to characterize it, I just want to make certain that the audit committee just doesn't have carte blanche to hire whoever they want to without regard to any process at all.
Staff will be ensuring that the process is in place before taking the selections to the committee. So that process will be in place to ensure that there's a fair process. And in the case of sole source, we would provide the justification to the committee.
Can I ask?
But what I'm saying is if the committee wants to sole source a particular contractor, advisor, basically, if they give you some justification, then you have to go out and do that. And I think there should be some kind of check or some level of oversight for that particular type of action.
I can't envision that happening, but if it did happen, it would be in an open meeting. So it would be vetted in that sense. It wouldn't be done. It would be done in with transparency.
So, Mr. Kryman, can you comment on that?
I believe that the way Mr. Bendel has described the process is accurate in terms of the independence. I do know that that normally I do get involved in terms of review. My staff does come to me with those procurements, and I would ask questions about the justification, the process that Richard went through, just as a normal course of business, because he can't contract without my staff. So, but in terms of the direction coming from the audit, that's definitely my understanding of the process for those types of procurements.
Okay, well, I'm just a little uncertain about that particular aspect of the audit committee having, there's no process in there for any kind of oversight at all by the board through any other officer, that if they wanted to sole source, that it in fact met the criteria for sole sourcing.
The board has delegated that authority to the audit committee. So the buck stops with the audit committee now in regards to hiring of audit professionals. But the oversight will be provided by the audit committee. And, you know, I think the audit committee will be holding staff to that same requirement. And, you know, the audit committee, again, will not have the oversight by the boards, but it will be at least evident and transparent to the boards on what the audit committee does.
And I think if you look at the audit committee, there are 5 members on each board that are on the audit committee, which was increased, as we know, from 5 to 7. I think that should give us a pretty, and both chairs and a vice chair and a secretary. I think that should give us comfort that a majority of each committee will be making that decision on the audit committee.
Mr. Bendel, I have Mr. Keogh in the queue, but I have a question that maybe someone can look up while Mr. Keogh is asking his questions, which is, if the oversight intended is that these considerations have to take place in open meetings, is it required in the audit committee charter that meetings be agendized so that all trustees can attend and participate in the discussion, even if they're not voting on the consideration?
The audit committee meetings are agendized that way, Mr. Chair.
Respectfully, is it that they are or that they must?
I believe they must. It's actually in the charter. I believe that they're agendized that way.
Okay, Mr. Keogh.
Thank you. Wayne has a very good question, and it raises a concern of mine, because during the audit committee discussion of this, I specifically asked if our procurement policies were going to be followed regarding these additional funds, and the answer that I received was yes. So that implies that there are procurement policies written.
Yeah.
And so in response to Wayne's question, to me, the proper answer would be that there is a procurement policy in place, and that procurement policy will be followed, and that you'll provide that procurement policy to the trustees so that we're aware of it.
That is correct, Mr. Keogh. And I
But
thought
what I heard was, so.
And admin services too is providing oversight too on that process.
Yeah, so I think that would resolve my concerns on my end is if we have a written procurement policy, it's in place, we're following it, and the audit committee is following it, then it's an open, it's at that point, there is no more issues with it. So that's what I need to hear from you, Richard, and from you, Mr. Kryman, if we do have specific audit committee procurement policies, or if we're following just the general procurement policies. So what is it? And then do we have them written down and can it be provided?
I have Mr. Santos in the queue, but JJ, did you want to speak to that point?
Yeah.
I just was going to say that everything would follow our normal procurement policies.
Mhm.
So everything has to be vetted. The administrative services division manager actually reviews pending contracts to make sure that all the proper procedures are followed in terms of solicitation. And that includes single source memos as well, to make sure that there's a strong business case for those memos, for that selection.
Okay.
So they have to follow the same types of process that everybody else does.
And then in the procurement policy, doesn't Mr. Kryman have the final say on sole source? And if so, if audit's going to do things differently, then it should be specified in the policy. Otherwise, it's still the buck stops at Mr. Kryman. But if what I'm hearing is that the audit committee can do a sole source, which is through Richard rather than through Santos, if that's the case, then it needs to be written down in policy. So I didn't get a clearly defined response. I appreciate that, JJ, and if that's what we're doing, if we're following the standard procurement policy, then the answer is Santos has the final say on sole source purchases. But if it's the other way around, then we should define that. So
I think that
I think we need a clear answer.
I think that that we're going to have to go back and take a look at it to make sure that it does say precisely what JJ just said. So so I think we'll go back and we'll clarify and we'll come back if there's anything different, and we'll report back either way in terms of what that procurement policy will be for sole source agreements and for contracting through the audit committee. So Richard and I will sit down with JJ and with Kim Hines, our admin services, and kind of walk through those steps. But JJ,
So with that,
Hold on. I'm going to hold over this item then until next month. We can continue discussing.
Thank
it. But under my
That's what I was thinking.
I'm going to move this item to next month's admin meeting.
okay.
Mr. Santos, I'm sorry. Thank you, Santos. Mr. Keogh, did you have any further comments? And Mr. Santos, you're in the queue if you wish to speak.
No further comments. That's exactly what I was going to suggest.
Mr. Santos?
Yes, thank you, Mr. Chair. Yeah, I agree that we need to follow the same procedures that we have for the rest of the organization. We're going to have two different policies, procurement policies. So I really appreciate the review of that. And the other suggestion I have is that whatever the audit committee does, that the boards will get a report for information only. Mr. Blendell?
Well, I think that we can certainly do that if that's requested by the boards. But I think it's important to note that there is a deviation from the standard procurement policy by definition in the way that the boards delegated through the approval of this charter, and in the past had done that, is approving the delegation of the hiring of outside auditors to the audit committee. So again, that is the one thing. We follow the procurement policy. We follow, I think that needs to be defined, and I agree with, meeting with Mr. Kryman and discussing that. But I think the intent of the charter changes was to have the audit committee be the selector, and that, so it is a deviation from the procurement policy at that level. And I think the intent was for it to be that staff would follow the spirit of the procurement policy in terms of all of the, practices of procurement, but for the escalation would be from staff to the audit committee. And I think that was the intent of that delegation to the audit committee. So we need to maybe refine that and make sure that, but that was what it was intended.
And through the chair, my request would be one that to ensure that the boards get an FYI memo on any activity, especially in the procurement area of the committee, because I think it's important. We're talking about checks and balances. I think it's important that the boards are aware of what's going on in different committees. Also, with regards to the procurement policy, and if there is any deviation that needs to be fully discussed with the boards, that needs to be approved. Either we follow the established protocols, or the boards fully understand that the differences between the procurement policy of the audit committee versus the rest of the organization, because other than that, it's going to create confusion in the future. So we need to spell it out. So I really appreciate the chair's direction to send this back to the staff to flush out those items that we discussed, and then we review this on a future date. Thank you.
And Mr. Santos, just to clarify, and Joanna, if I get this wrong, jump in. My direction is to give staff the month to clarify these items. Mr. Santos's point about the FYI members is an interesting point. I'm not sure that is authorized. So if upon reflection, staff needs to send this back to audit to further develop their request, I'm certainly fine with that. But if everything can be resolved and brought back at our admin meeting in June, that would be great.
Right, that's the pending motion, and I think we're looking for a second, whether to continue it to next month.
I don't believe that under my authorities it requires a second. I believe that I have the authority to move it to the admin meeting.
Even though it was an action item, okay.
And just in support of the chair, since there's no objection.
Mhm.
I will happily say without objection, just to cover all bases, without objection, we will continue this until next month's admin meeting. Thank you, Mr. Santos. Then we are going to move on. Thank you, Mr. Moore, for raising this. We are now on report 7A, a presentation by our fiduciary counsels, Ashley Dunning and Peter Mixon from Nossaman, regarding First Amendment training, free speech rights, and fiduciary duties. There's a memo dated April 6, 2021, and there is a presentation. I'm not sure who's kicking it off, but I will turn that over to staff or council.
Okay, yes. We're going to have another presentation on First Amendment and fiduciary rights. We're starting a little bit early. I know Ashley had another meeting, but Peter is prepared to give the presentation if she's not on yet. And they have slides, 12 slides, but they also have a memo afterwards too that's very useful and helpful. Even though it's they gave this presentation about a couple of weeks ago, since then there's been a Supreme Court case that has been accepted on First Amendment, also involving trustees. So those that paid attention last time might want to pay attention again, because Peter, I think, is going to talk a little bit about this new case. And yeah, so let's go ahead and get started. Oh, one last thing. For the lawyers that are interested in getting CLE credit, both staff and trustees, listen closely, because Peter and Ashley will be given a code, and you have to give the code to be able to get the credit. So pay attention for that. And without anything else, and I understand Ashley has joined us, so that's great. We'll have both of them. All right, take it away.
First of all, I want to thank everyone for the opportunity to present this morning with my partner, Ashley Dunning. If Ashley is on, she was going to take the first few slides.
I'm here, Peter.
Okay. I was ready to go, but that's the original plan.
Yes, nice to see you all. Good morning. So as Johanna mentioned, you will get CLE credit for this. For those of you who are attorneys and would like to get that continuing legal education, the code that you'll need to send to our offices after the meeting is 973. Please write that down. It's important that LACERA not communicate that code number to any of you, but just Peter and I during this presentation, just to preserve the integrity of our CLE process. I'll give you the code again at the end of the meeting, and we'd ask that you send your request for CLE to our offices at Nossaman Professional Development at nossaman.com, and identify the time that the training started, which is 9:30, and the time that it ends, which we anticipate to be about 10. Okay, so with no further ado, if we can move to the next slide, please. So today we are talking about free speech rights under the United States Constitution and the California Constitution, and fiduciary duties of trustees of public retirement boards, and sort of the intersection between those two very important legal principles and the challenges that sometimes arise with respect to trying to reconcile different aspects of those legal principles. As you all know, the fiduciary duties that apply to all of you are your duties of loyalty and prudence. The free speech fundamental component of this presentation, which is newer to our discussions with you, derive, as I mentioned, from the US Constitution and the California Constitution. And we note, and we'll talk about this further, that the right to free speech under both of those constitutions is not absolute. There are some forms that are, some forms of speech are protected. We've listed those here. Some forms, as we all know, are not. And those are also listed in part here. And then that statutes to some degree may regulate protected speech in certain contexts. And we've identified the seminal US Supreme Court case on that, which talks about weighing the governmental interests involved in regulating the particular speech. Before we launch too much more though into this, we want to make clear what we're not talking about here. We're not talking about trustees' ability in their roles as private citizens, or even in their professional lives, from communicating as you will about matters that don't relate to LACERA. So that is not what this presentation is about. This presentation is only about each of you speaking with your LACERA trustee hat on, speaking about LACERA, that sort of thing. So that is the focus of today's presentation. Next slide, please.
So before we dive into the nuts and bolts of balancing the interests that Ashley spoke about, we wanted to mention briefly this California Supreme Court case, which applies to California public agencies. And that is Stanson versus Mott, which is cited here. First of all, public agencies in California do have a right to speak freely, provided that it does not drown out private communication. However, there is a restriction on the expenditure of public funds to influence the outcome of an election. And that's embedded in the California Constitution, so that, as Stanson held, unless there is a very explicit legislative authorization to expend funds to influence an election, that those expenditures would be considered a gift of public funds and therefore unconstitutional. On the other hand, if there is a general legislative authorization, for example, to provide the public information about the activities of the public agency, then this authorization supports a, quote, fair presentation of information relating to the electoral issue. In other words, one that doesn't constitute electioneering. So pamphlets, floats, advertisements, radio, TV ads, that sort of thing, it's clearly out of bounds here unless there is a very explicit legislative authorization for that kind of expenditure. And that's currently reflected in your current Code of Ethics policy. Next slide.
This slide addresses a balancing test that the courts, the US Supreme Court and the California courts have agreed applies in certain aspects of government service. The phrase that we think is most pertinent when thinking about this in the context of our discussion today is quoted here, and that is, when a citizen enters government service, the citizen by necessity may accept certain limitations on his or her freedom. Now, the way in which that's most commonly discussed and applied in cases is with respect to public employee speech, as potentially distinguished from trustee speech. However, as noted, we think that the entering government service notion is one that we view as really pertinent to the analysis we're discussing today. And in the context of this analysis, the US Supreme Court developed a two-part balancing test where they weigh the interests of a public employee as a citizen to be able to comment on matters of public interest on the one hand, and then on the other hand, the interest of the government acting in these contexts as an employer to promote efficiency and effectiveness of public services that it performs. This is the Garcetti case. And Garcetti has been applied in California to the free speech right of California public employees in the Kay case. Our application of these principles to LACERA trustees occurs in the context of thinking about the trustees as accepting certain fiduciary responsibilities and certain corresponding free speech limitations with respect to your LACERA speech, again, not with respect to your private citizen or professional speech in other contexts unrelated to LACERA, and that applies upon your entry into government service as a trustee on one or both of the boards. Next slide, please. Where the application of the government speech balancing test is most challenged in the public arena relates to the speech of elected officials. And there's a split of authority on that topic as to whether that balancing test is appropriately applied to an official who's run for office in a traditional election. And this is not applied specifically in a retirement system context. It's applied more similarly to, say, a board of supervisors election or a city council election. And there's a split of authority in the federal courts on whether or not the balancing test properly applies in that context. So stating again our view on the applicability of this balancing test here, we have concluded that we believe that the government's, and including LACERA's interest, and that's LACERA as in the boards of LACERA, the boards of LACERA's interest in ensuring that the boards meet their constitutional responsibility weighs in this balancing test. And if that, and applying that balancing test, the rule is restricting speech that owes its existence to a public employee's professional responsibilities, in this case, responsibilities as a trustee of LACERA, does not violate free speech rights. Once again, this is not LACERA restricting board members' speech. It's board members determining whether or not you as boards wish to take actions to potentially regulate further the speech of one another for the furtherance of your collective fiduciary responsibilities. Next slide, please.
So there are a couple of federal cases that examine this intersection between the constitutional rights of free speech, and actually another case of freedom of religion under the First Amendment, and fiduciary duties that are owed by the speaker. The first case that's mentioned in the slide deck, SNEP versus United States, we wanted to talk a little bit about because it does have a bearing here. In that case, a former CIA, the Central Intelligence Agency agent, decided to publish a memoir about his experiences as an agent. When he was first employed as an agent, he signed a contract in which he agreed that he was a fiduciary to the agency, and he also agreed not to publish a book without getting a pre-approval of the agency. Well, of course, that's exactly what he did. He went out and published a memoir which detailed his experiences as a CIA agent. So he was sued by the agency, and the case ultimately got to the U.S. Supreme Court, which held that the government had a right to bring the breach of fiduciary duty action, and in fact was upheld the finding in favor of the agency for breach of fiduciary duty. But in addition, it upheld a specific remedy for breach of fiduciary duty, and that is the imposition of a constructive trust on the profits of the individual agent that would be earned from sales of the book. And the court specifically mentioned that this is an appropriate remedy for breach of fiduciary duty. And all of this holding is in spite of or nevertheless consistent with the agent's First Amendment rights. In the second case, that is the Askew case, this is not a free speech case, it's a freedom of religion case, but the freedom of religion is also embodied in the First Amendment. So the court held that a member of the congregation had the right to bring a breach of fiduciary duty case against the trustees of the church, notwithstanding the general abstention or policy, I guess, or doctrine of the court to stay out of these kinds of disputes when they involve internal church organization because of the free exercise clause in the First Amendment. And the court held that the fiduciary duty laws were neutral when it comes to enforcement, and so and regarding church doctrine, they could be neutrally applied, and so the court allowed the case to proceed on a breach of fiduciary duty claim. So these cases to us represent an intersection of the fiduciary duties and constitutional rights, and the court's holdings signal that courts will uphold an individual's fiduciary obligations, notwithstanding the First Amendment rights. And then finally, we talk about the case of Phelan here, which is the case that Johanna alluded to, or more accurately, there's been a developments on this front very recently. So in Phelan, a community college board passed a censure resolution reprimanding an individual who was a member of that board for taking out an ad in a local newspaper which strongly criticized the board for a position on a bond issuance. And the court held that notwithstanding the individual's free speech rights, that she was not injured by the board's action there, at least her First Amendment rights were not injured, number one. And number two, the board itself likely had First Amendment rights to express their opinion on her conduct. Now, in the last 2 weeks, the United States Supreme Court has granted certiorari, which means they will be reviewing a case that deals with this issue. This case, the new case, is that of Houston, and it is also a community college board where one board member had, over the course of a number of years, taken a number of objectionable actions, including making or commissioning robocalls, negative robocalls against individual board members, hiring a private investigator to conduct investigations, and also speaking out in media over and over and over again, making negative and disparaging comments about the board itself and other board members. And so the board passed a censure resolution, and that individual sued under the First Amendment for violation of his free speech rights. And that case is now in front of the U.S. Supreme Court. So we'll put a caveat on this particular issue. It's obviously a very big case, even beyond public pension systems. If you think about it, it really implicates all governance policies or ethics policies when it comes to local agencies in this country. So we're definitely going to be following that. Next slide. So here in this slide, we talk about our overall legal conclusions regarding the intersection of these two concepts, free speech and fiduciary duties. First of all, there is no free speech exception to the fiduciary duties owed by public pension plan trustees. LACERA board members voluntarily enter governmental service as trustees in actions that are, and this, we want to make this crystal clear, that are within the scope of their duties as board members, are subject to fiduciary obligations. And all board members are subject to reasonable board governance policies that may potentially restrict their speech. When it comes to enforcement of those policies, we're going to have to put an asterisk on that statement because of this the Wilson case that is now in front of the United States Supreme Court. But nevertheless, these governance restrictions reflect the collective decision of the boards applicable to all co-trustees. Third point that we've derived is an individual trustee's interest in free speech will be weighed against the interests of the boards in having board members effectively govern themselves individually and collectively for the overall benefit of LACERA. And once again, I think we said this a number of times, the government each balance of interests must weigh the fiduciary responsibilities of all board members to act consistent with their duties. Next slide.
Continuing on with Peter's themes here, looking at your governance framework, the fiduciary duties owed by a prudent LACERA trustee apply to all statements that you each make as trustees when you're speaking as trustees. The next bullet point, we need to make clear, when we say that statements by LACERA trustees as a private citizen may still be subject to a balance between free speech rights and the interests of LACERA in meeting fiduciary responsibilities. What we intend to say there is that simple disclaimers may not be sufficient to make it clear that you in fact are speaking as a private citizen. If you are in fact simply speaking as a private citizen and you're not talking about LACERA, then you wouldn't be subject to this balancing test, I don't believe, or you know, noting in the context of your statements that you are a LACERA trustee. If you're not saying anything like that, then this is not implicated. But what we're talking about is if you're speaking as a trustee on the board, identifying yourself as such, then your fiduciary responsibilities are implicated. So simply disclaiming that you are not speaking on behalf of the organization or on behalf of the boards doesn't mean that you're not speaking as a fiduciary. And so the ethics and fiduciary policies of the LACERA boards may reasonably govern the content and manner of trustee speech when people are identifying themselves as LACERA trustees or talking directly about LACERA. Next slide, please.
So in this slide, we wanted to give some examples to flesh out some of the principles that we've been talking about. So first of all, trustee statements made from the dais are subject to fiduciary obligations. Seems obvious, but sometimes it's important to state the obvious. That is not even to suggest that any of these concepts are designed to put a damper on advocacy, debate, and vigorous debate and advocacy on matters in front of the board. But of course, acting as a fiduciary, always in mind with the fiduciary mission of LACERA. Second, trustee statements made to the media or in public speeches on LACERA matters, even as a private citizen, will likely be construed as statements of a representative of the organization. And that is because if a matter is in front of the LACERA board or was just in front of the LACERA board, just the simple identification as a trustee, I mean, that infers some official status, at least in the minds of those who are listening to the speech or taking in the speech. And so that, again, we want to emphasize, though, that is not to say that the reach of these concepts goes into, you know, the day job of an individual, or when they're clearly have nothing to do with LACERA business. Statements of personal opinion, again, about LACERA matters, could have an impact on the retirement system itself. And therefore, one of the concepts that we're putting forth here for board or consideration by both boards is the impact of speaking or signing written statements and the consultation, let's put it that way, with appropriate officials, whether that's the board chairs or the CEO, the CIO, or the chief counsel, in advance of publication of statements about LACERA matters. And that's not to say that, again, this is for consideration of the boards from a governance perspective. It's not to say that any of these individuals would have veto authority or could stop the speech or anything of that nature. It's simply a governance issue, so to speak, in terms of providing heads up to the organization itself that this may be coming. And second, to have a discussion about the implications of the speech on the organization. And again, trustee statements on topics unrelated to LACERA business are far less likely to implicate the fiduciary mission of the system. Next slide.
So LACERA, the boards already have adopted a couple of policies that address communications, but and we've identified them here. And what we're intending to do here is just sort of highlight what they do and don't cover now, as a way of thinking about where the boards may go if, after consideration of the topics in this presentation, the boards think that additional work should be done with respect to the topic. So in your media policy, the focus or the purpose is to ensure that the policies of each of the boards are accurately transmitted and explained to mass media representatives. The policy is stated as a guide rather than a mandate. And it also serves as a guide with respect to communications with, it says, all outside parties. So even by its terms, it doesn't appear to be limited to media, so that it could arguably cover contacts with others who are not the media. The policy says that board members are encouraged to refer media inquiries to staff. So again, it's sort of a recommendation as opposed to a mandate. And also says that board member responses to media inquiries should use discretion to limit the discussion to formally approved board policy. So again, wise counsel, but not a mandate. Personal opinions and speculation about board member or staff motives, it says, quote, are to be avoided. And personal opinion regarding LACERA and its business must be clearly identified as such. And so that's where you get the current authorization to make statements about LACERA business and say, I'm not speaking on behalf of LACERA, I'm speaking only in my individual capacity. that appears to be authorized by this media policy. But as we've noted, even when one does that, often it will be taken as an authorized statement of a representative of LACERA, which is why the media often will care about it. It says all media contacts will be reported to the board, and board member contacts with outside parties concerning LACERA should be conducted in accordance with the intent of this policy. Again, a recommendation. Next slide, please.
The next LACERA policy we're going to talk briefly about here is the portion of the Code of Ethical Conduct, which relates to political activities. No LACERA funds, property, logo, or other resources may be used to support personal political activities. Board members and staff may not use their influence or their position to secure a vote or other support for a political campaign. And board members and staff, quote, may use their LACERA position to identify themselves when making an endorsement, provided that no statement may be made or action taken directly or indirectly indicating that the person represents LACERA in making the endorsement, or that the endorsement is supported by or represents the position of LACERA, except of course when providing information that has actually been authorized by the board or by the board.
Slide, please. So we get to our final slide, which is to set forth some topics that we think are worthy of discussion and questions. And we, of course, welcome any additional topics for discussion or questions by board members. The ones that we've put forth here are just to query whether your current policies are sufficiently clear so that all board members understand their responsibilities and their compliance obligations. As I noted, there are many recommendations within your media policy, but really no mandates. And so the question arises if board members choose not to follow those recommendations, is there anything for a board chair or a committee chair or anyone else to say on that matter or not? Second, are the interests of LACERA and its governing boards in effectively functioning as an organization sufficiently identified in these policies? Have the fiduciary duties of the boards and of the members of the board been sufficiently considered in these policies? Do the policies reflect and or respect the roles and responsibilities of trustees and executive staff? I think that's a point that's worthy of pausing on just for a moment, because as Peter mentioned, sometimes a simple heads up to your executive staff regarding what might be in the media will help the boards and will help the organization to at least be able to have a sort of thoughtful response or not if they're asked about something. But when there isn't that sort of heads up, there can be some pretty substantial challenges for the organization that the boards probably don't want to bring on the organization, or may not want to, at least collectively. Which leads to this next question, which is what role, if any, and that's a true if any, should the board chairs or the committee chairs, if you're dealing with a specific topic assigned to a particular committee, or your the heads of LACERA, the CEO, CIO, or chief counsel with respect to legal matters, have in consulting with any board member in advance of the member making public statements. Again, not to give that person a veto power, but rather to, no, not necessarily, and that's certainly not what we're recommending, but rather to have that sort of consultation occur before publication, if you will. Getting additional insight, giving a heads up, or getting input if warranted, additional thoughts before publication, and certainly a heads up to the organization. This next question comes up pretty frequently in different contexts. What role should the board chair and or the boards have in enforcing policy requirements? If you have a circumstance where members of the board are concerned about something that's happened, what do you do about it? How do you govern yourselves or not? Is there a means by which to do that? And it's not uncommon at all within a governance structure to designate to the one whom you've elected to a position of governance authority, which is your chair, so the chair of a board or chair of committees, to have certain responsibilities in that regard. And so that's simply a question for your consideration. And then, of course, if you have other questions or comments, we welcome them. Next slide, just to round this out so I don't forget to remind you or tell you again that the code for this presentation is 973. It's 10 o'clock, so the presentation's gone the half hour promised, but we welcome questions and comments within the time you would like. And if you are seeking legal education credit, please submit your request to Nossaman Professional Development, all one word, no caps, at nossaman.com, and indicate the time in of 9:30 and time out of 10 or whenever we complete this presentation. Thank you.
Thank you, Ashley. Thank you, Peter. I imagine there'll be some questions or conversation, but I don't see anyone in the queue yet.
Alan, I have a question, if I may. I think Ashley brings up.
Go ahead, Mr. Zucker.
Can you hear me? Alan, can you hear me?
You're a little scratchy, but we can hear you.
Let me turn this up a little bit. Is that better?
It is better, yes.
Okay. I was just wondering, we don't have anything in place for violations of these rules of free speech and what you just went over. Ashley, and Alan, maybe I'm out of, I'm not correct here, but I would like to see what other organizations are doing when somebody steps out of bounds and does things that they should not be doing, you know. And I don't know how we treat that, because we don't have anything in place now to handle somebody that's handling this incorrectly for LACERA.
So Trustee Oakham, that's right, you don't. One of the comments that Peter made during his part of the presentation was there is now this case that's been accepted for review by the US Supreme Court that considers the extent to which censure or other remedies impede First Amendment rights or not. So we've put a bit of an asterisk on that. What I'd say about other systems is if they do have remedies included within their governance policies, it typically is along the lines of either a public or a private censure, and there are different ways in which one gets to one or the other of those. Potentially including, worst case scenario, not being removed from office or positions and those sorts of things, travel privileges revoked. But that's really as far as you can get in terms of a SERL system or public retirement system, because there's just no authority for further punishments like removal from the board. I've been asked that over the last couple of decades in really bad situations. I don't see any means by which to do that, but certainly there are systems that have adopted some enforcement, typically focusing on censure, public or private, in some of the other systems.
I would ask one question that I might be out of. Have a summary. If we could have a summary, can you hear me?
Yes.
Okay, if we could have a summary of what you just gave us about First Amendment training with the highlights, maybe in a 2-page document, not all the specifics, that will remind, we don't want to have any censure, we don't want to do that kind of stuff. But if we could have a reminder of what our responsibilities and particularly what we can do would be very helpful for us to look at that and say, okay, I can't do this. Or I need to ask Steve, or I need to do whatever to make sure that never happens, because the board never should be put in the position to censure someone or one of our friends, one of our colleagues. And I think that would be helpful for the future.
Ashley, if I heard it correctly, there was a request for a clarification. However, I'll leave it to you, but I'm not sure that the media policy doesn't already effectively provide that. So I'll refer it to you, but that would be my thought.
Chair Bernstein, I think you're right. And I think the response I'd give to Trustee Oakham on this is that the media policy and your ethics policy currently provide what you've asked for, but it's in the form of recommendations. There aren't any, you may not do this, or this will happen, or you must consult with chief counsel or the CEO. That's what's not in the policies. And so really that's why we're here today, just to have you talk collectively about that. Is that something you think is important? Is that something that you would like to require of one another, of yourselves and one another? And if so, that would need to be written into a policy before we would be able to summarize it for you as LACERA, as the board's policies, if you will, because you've done a good job of identifying the current policy. We're simply saying the current policies don't give you any enforcement mechanism, and they're far more advisory than anything else.
And Mr. Oakham, I wasn't trying to comment on your comments. Just to be clear, we were having a hard time understanding you. It wasn't a great connection. I have Mr. Santos in queue next.
Yeah, Alan, I got my microphone in the right position now.
Now, of course, it's better.
Thank you.
Thank you, Mr. Chair. Yeah, I was wondering if you can provide us with the citations for the Wilson case that is pending before the U.S. Supreme Court. Certainly, I would love to be able to review that case and look at the issues that the Supreme Court will be tasked with deciding. And the comment that I have is that we need to be really careful in what we do and what limitation we place. Because just to give you an example, I became alarmed about how well our real estate portfolio had been performing several years ago. And I made that, I expressed those views both on the record during the Board of Investments meeting, as well as privately, because I was really concerned. And that went on for several years. The consultant disagreed with me, the CIO disagreed with me, and my colleagues on the board at the time disagreed with me. And that went on for several years, but I was still not satisfied until Mr. Grable was retained. And when he came to visit me at my office in his first 30 days, I believe, he asked me if I had any concerns. And I told him, I'm concerned with the real estate portfolio. He said that he was going to review it, and he did. And I don't know, 30 days later or something like that, he communicated with me again, and he said, yeah, there's some issues that we need to work on that. And I believe since then he has implemented a program that I'm very satisfied. The point that I'm making is that certainly as a trustee, if I believe that we are doing something like in this case, the portfolio, nothing illegally, which is that I wasn't happy with the returns and how we were going about investing in the real estate portfolio. We have to be able to criticize and raise concerns whether we are mistaken or not, because that's what I believe I was elected to question and to continue to push if I'm not convinced with the response that I'm getting from the consultants or the staff, whoever. So we need to be really careful here, because certainly as an elected official, I have the right to raise issues, or I should have the right to raise issues when I believe sincerely that there's something wrong there and I wasn't being listened to, like in my case with the real estate portfolio with regards to the consultant at the time, the CIO at the time, and some of the staff at the time, to the point that I remember at one meeting, I felt humiliated by the comments that the consultant was making, for me questioning how well the portfolio was doing. So we need to be really careful. That's my point. And I would really appreciate if I can get a citation from the Wilson case. Thank you.
So we're happy to, we'll provide the Wilson citation, of course. And let me just make a brief comment here. I mean, as a fiduciary, it's not just a right. You are charged with the responsibility of overseeing the investments of the system. And so that is critical to your status as a fiduciary, to raise issues and to get answers in your oversight role as to the investment decisions, whether real estate or whatever, of the system. And so that's not, the concepts here that we're talking about are not designed to inhibit those responsibilities at all. It's really a question of thinking about time, place, and manner of communications, and the method that the trustees use in terms of how they exercise their responsibilities in making sure that the system is fulfilling its duties to the members and the beneficiaries and investments and otherwise. So that's, I think that that's a great question and example that you gave, and I think it's important to keep that in mind.
Thank you both. Mr. Moore. You're muted, sir.
Yeah, I'm not anymore. I want to just follow up on what Mr. Santos said about being very careful about how we approach this whole issue of free speech. Because from my perspective, although we've been cited with a lot of information, you know, it's still as clear as mud to me about what the boundaries are. Because just what fiduciary responsibility is a subjective term, or can have a broad or narrow meaning in itself. So you can't prescribe what fiduciary responsibilities mean clearly. And for example, if you know, in my position, and I've articulated this more than one time, you know, I see 20% of our beneficiaries and contributors being African American, 70% being minority, and yet all of our money is being vested by a group of white guys in New York, just to use a euphemistic phrase to include everybody. And that's a problem. That's a problem for the people whose money it is. And if I want to articulate that in any forum I want to articulate it in, I should be allowed to do that. And the fact that I'm a trustee only means that I have credibility at some level and I'm informed when I talk about it. And it's no dispersion on LACERA specifically, because it's the environment that we live in the financial services industry. And so, you know, all of these things are in the public discourse. They're concerns to all different groups. Everyone has an interest in it. And sometimes we have to talk about and discuss things that are not comfortable, but need to be addressed. And so, I think, one person's idea about what should be protected speech or not protected speech and another person's on the same board could be diametrically opposed to each other. And so I just think we got to be very careful moving forward and error on the side of freedom and error on the side of allowing people to do what they were appointed to this board to do, which is represent various perspectives and ideas on how we ought to approach our job.
Thank you, Mr. Moore. I don't have anyone else in the queue. So Ashley and Peter, I'll thank you very much for another excellent presentation. If you have any final comments, or Johanna, if you want to wrap up, that's fine. Otherwise, we will get ready to move on.
Yeah, no, I just want to thank Peter and Ashley for a good discussion, and for the board trustees for their very enlightened questions and comments as well. No, I thought it was good. Thank you.
I agree.
Oh, and Mr. Santos, I have the citation of the case also, and actually a write-up by one of our analysts, so I will send that to you. Okay.
Thank you again for being here, and for I can't remember the term for the credit, but I'll call it 10/16. So you get 46 minutes of credit if you need it.
CLE. I'm afraid we get 30 minutes because that's what's been pre-approved, but it's good 30 minutes. We thank you so much for your time, attention, really good questions and observations. We agree with you that this is a topic that warrants careful consideration. We don't want to suggest that any form of chilling speech is appropriate, because as fiduciaries, you do need to be able to engage in vigorous debate and express your opinions on important matters. It's also a governance topic, though, that warrants your full consideration. So we hope we were helpful in that process, and wish you a good rest of your meeting. Thank you.
Thank you.
Before you go, Mr. Chair, may I ask the last question? Yeah. How come this is not ethics? I mean, this is ethics, and we should be ethics credit, not general credit.
So ethics credit for continuing legal education relates to the relationship between attorneys and their clients. So even the ethics for public officials training that I give Trustee Santos for 2 hours that I know you've taken a few times, as have other of your fellow trustees, I can't give ethics credit for that because that's ethics of public officials as opposed to ethics of lawyers to their clients. That's why.
Thank you.
All right.
Thank you very much.
We will move on. Thank you again. We now have 4 other reports that are for information only, items 7B through E. I did not have any requests to pull them for discussion. So unless somebody wants to jump in now, we will move on to item 8, items for staff review.
Yes, I just have one. The board requested that consent item B, which refers to the revised audit committee charter, be held until staff can clarify and review questions raised regarding the procurement policy and sole source agreements.
Great. We're now on to item 9, good of the order.
Mr. Pryor.
I have nothing, thank you.
Thank you, Mr. Knox.
Just speaking on myself as an individual, I want to wish everybody a happy Wednesday.
Thank you, Ms. Gray. Thank you, Mr. Santos.
Just thank you very much for that. I just want to express how sorry and for losing one of our esteemed lawyers in the legal division. It really hit me hard. I just hope that her death brings goodness to everybody involved, especially the family. It is something that we need to remember that a lot of times, we don't know what's happening in people's personal lives, backgrounds, where illnesses or any other issue. So we all need to be sensitive about it. Many times, we go out, moving 100 miles an hour, and we forget to think about the people that we work with and the personal issues. So sorry to hear that. Nothing else. Thank you.
Thank you, Mr. Santos. Mr. Oakham?
I have nothing. Thank you.
Thank you, Mr. Moore.
I have nothing to add.
Thank you, Mr. Kehoe.
Nothing, thank you.
Thank you, Mr. Robbins.
Happy Cinco de Mayo.
Thank you, Mr. Harris.
Nothing to add. Thank you.
Thank you, Ms. Zapanta.
Nothing other than happy Mother's Day to all mothers and people in a mother role or nurturing role. Thank you.
Thank you. Johanna Fontenot.
I have nothing. Thank you, Bonnie.
Thank you. JJ Popowich.
I have nothing. Thank you very much.
Thank you. Santos Kryman.
Nothing for me. Thank you.
Thank you. And Chair Bernstein.
I will accept Ms. Zapanta's Mother's Day wishes, and I will return them to her and to everyone else who's busy raising children. And I know, and we're all aware that the county has moved into the yellow tier. I believe there are changes taking place tomorrow. Clearly, there's a correlation with COVID and age, and there's a correlation with our membership and age. So this has been particularly, I imagine, on the minds of us and our membership. And it's really gratifying to see real progress occurring. And here's to more continued progress. That's all I have. We now will be going into closed session. It's 10:21. Let's break until 10:30 so that people can stretch if they need to. And then we will take disability retirement cases to be held in closed session.